It's fine, Chair. Just to say, we didn't realise that the format was questions and answers, but that's okay. Some of the points have been raised. I just want to echo what Deputy Murphy O'Mahony said. I suppose I thought that was just an excellent point in general on behalf of all the women of Ireland and all the women particularly affected by this. And Deputy Donnelly has raised the issue of the backlog. That was one of our questions, just exactly how long people have been waiting now. We know at one point it was 27 weeks. I'm going to just group the questions together. I think that might be the easiest, because there's really two main ones apart from the issues that have been raised already. One of them is in relation to, obviously we welcomed the fact that people could have their hearing in public or private, and that's very important for women, and that their kind of wishes are respected in that manner. In relation though to women who have already received a court settlement, as I understand it, they are not allowed to give evidence to the tribunal, and obviously it's totally understandable that you can't have a second claim in regards to anything, but it is important that all those who are affected by this are allowed the opportunity to give evidence to the tribunal to help in its deliberations. So can you, Minister, confirm, is that the case, that women who have already received an award are barred from giving evidence? If that's not the case, I obviously welcome that, but if we could just get some clarity on that, and if it is the case, why would they be stopped from giving evidence? Or not obviously looking for a second award. And then obviously it's been raised about the recent judgment, and I just want to ask a specific question around this. What, Minister, is your own view and the Chief Medical Officer and the Attorney General's assessment of this ruling, and where lies the future of screening programmes as a result of this? Thanks, Chair.
Thanks very much, and thanks for the grouping of the questions. So in relation to your point regarding the Meanin legislation, I think it's a fair point you make. You quite rightly say, of course, people can't, and nor would they wish, to have two claims or go through two processes. I think the question you're asking me is, if a woman has gone through the court but would still like her experience to be documented by the tribunal, is that possible? My understanding, and we've obviously at a general scheme stage at the moment, my understanding is that the legislation is currently silent on that. So I think that's something we can probably accommodate, and I'm happy to work with you and your party spokesperson on as we progress the legislation on how we could advance that. In relation to the recent legal case, I don't believe I've probably anything further to add to what I've already said, other than I believe it's going to require very careful consideration by the Attorney General. I think we need to look at the impact not in relation to the individual case, and I think we've all been very clear, and I think we're unified as a House in relation to wanting to see Ms Morrissey supported, wanting to see her receive the compensation that the court has awarded her, and wanting to see her being able to enjoy time with her own family, as she outlined after the court case last week. But there may be broader issues for the health service that we need clarity on. And today I'm only at the stage where the attorney is considering these matters, and he will revert to myself and the Taoiseach, and in due course we'll consider how best to get that clarity, because as Deputy Donnelly rightly says, there are many medics now saying what is the implication for screening, what is the implication for other elements of the health service, and we are duty bound to answer that question, and how we answer that in a way that doesn't adversely affect Ms Morrissey but does provide legal clarity is something we'll be considering in the coming period of time.